Hello? I have no idea if anybody's here, but if you are, hello? I have no idea if anybody's here, but if you are, hello? I have no idea if anybody's here, but if you are, hello? I have no idea if anybody's here, but if you are, hello? I have no idea if anybody's here, but if you are,
That's good enough.
hello? I have no idea if anybody's here.
Hey, what's up?
But if you are,
That's good enough.
hello? I have no idea if anybody's here.
Hey, what's up? Hey, guys.
But if you are,
That's good enough.
hello?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up? Hey,
You're
guys.
really annoying. If you are,
That's good enough.
hello?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up?
I can't
Hey,
read
guys.
it. If you are,
That's good enough.
hello?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up?
I can't
Hey,
read
guys.
it. If you are,
60 mile per hour wind world.
hello?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up?
Pick your head
Hey,
back.
guys.
If you are,
60 mile per hour wind world.
hello?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up?
Pick your head back. If you are,
60 mile per hour wind world.
hello?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up?
Pick your head back. If you are,
60 mile per hour wind
You
world.
hear three of me?
Yeah, so I talked about this earlier with
I have
Kat.
no idea if anybody's here.
Hey, what's up?
Pick your head back. If you are,
60 mile per hour wind
See,
world.
I was like semi.
Yeah, so I talked about this earlier with Kat.
It's a choir
Hey,
for
what's up?
me.
That sounds like 60 mile per hour wind
See, I was like
world.
semi.
Yeah, so I talked about this earlier with Kat.
It's a choir
Hey,
for
what's up?
me.
That sounds like 60 mile per hour wind.
I think. Okay, is that better? Oh, it did that last time too. Okay, yeah, I had my YouTube open, but it wasn't playing. Man, that Richard Allen thing's kind of fucked up, huh? Next time do a Christmas Carol, like the Rage Against the Machine one? When they went on the BBC and did... Yeah. There's that dude that looks like a bear. All right. So this is going to be pretty informal. And I'm saying that because it's going to be the same stuff I usually say, but I don't want to be accountable for it. I mean, by like page 60, I was just trying to like survive, to be honest. Right of the Halkeries. Yeah, I was just trying to like have my voice survive and my throat survive by like page 60. At some point I'll go back and do like more of an analysis-y sort of thing. But okay. So I don't know if I'm gonna read this whole thing. I probably will. I don't think it's that long. I feel like people don't really appreciate how dumb this case is, because there's actually like a lot of texture. There's a lot of different reasons why this case is dumb, this civil case. Like there's this whole thing. Let me see if I can find. There's this random jeweler that got mixed up in this case that was trying for years just to get a hearing, and their filings got like more and more sad as the years went on. Raffaello. And you're supposed to get a hearing within 90 days. And they just kept filing these motions that got just increasingly despondent as the years went on. Third motion for hearing return of property. Since the seizure, claimant has been trying to get his property back. Unfortunately, he has not even been able to get a hearing scheduled before the trial judge for over 2 years. Oh my goodness. Okay, here we go. Jeffrey Williams II files his motion to dismiss. On August 18th, 2025, They conducted a final forfeiture hearing in the above referenced case, and after the introduction of evidence and hearing argument, does he really? This honorable court granted Mr. Williams' motion to dismiss. A final order was entered on August 22nd. It's funny, from what I remember, the hearing was like 14 seconds long. It's basically Whitaker just saying, yeah, it seems like you guys dropped the ball. On about September 19th, 25, so you have 30 days to file a notice of appeal. So if they did, barely. File a notice of appeal from the court's August 22nd order of dismissal. The state requests that the court, and this is standard language, the clerk will omit nothing from the record. The state requests any and all transcripts filed into this case be sent to the appellate court as part of the record in this case. Let me see if we can find you an example of one of these. No. Yeah, whatever. Okay, OCJ 5642, the state is required to have prepared and filed a transcript of evidence and proceedings to be included in the record on appeal and to do so within 30 days after filing the notice of appeal. It's not uncommon for these things to take a while, especially if you have a really long transcript. But the transcript in this case couldn't have been more than a few pages. Prior to the hearing, the honorable court informed the parties via email that the court would not provide a court reporter, and that if the parties desired to have the proceedings taken down, the parties would be responsible for getting their own and paying for their own. Thug offered to split the cost with the state, and the state ghosted him. They left him on red. I'll show you that email real quick. This is from the Steele Law Firm. Mr. Root, I hope you are doing well. We are in receipt of the notice of appeal in your email requesting the card of the court reporter. As known, prior to the forfeiture hearing, the court instructed us that the court reporter would not be provided, that we would need to secure a private court reporter, and that we should coordinate to ensure that more than one reporter was not present. Thereafter, on more than one occasion, we advised that we were securing a reporter, and we reached out to you to determine if the state was willing to share in the takedown of the hearing. I did not hear from you each time that I reached out. While the Georgia Supreme Court has procedure by which a party can bar the other party's access to the transcript when they do not share a takedown, we do not seek to do that, and factors necessary for same may not exist. He's so formal. However, a court has the ability to require a party who did not share a takedown to reimburse the other party for a full payment. Because the state did not share, we were billed for the full expense. Attached, please find the receipt which we paid for the takedown. Please indicate whether the state will promptly reimburse us for half of the takedown. If not, we will file a motion seeking same with court. So fucking stupid. Oh my goodness. It's $200. Okay. That's less than one billable hour for a special counsel. All right, let's see here. October 20th, the last day permitted by law to file the relevant transcript, the state filed its first motion to extend deadline to file transcript. Yeah, it was like 208 something. You know what's funny about the 208 is they actually like seized, they had just done a a settlement agreement with Duke like the day before. So they definitely had the money. Let me see if I can find it. Civil forfeiture. Let's see if I have it. Let me see. I don't have a settlement agreement handy, but Duke let them keep like, I think like 10 grand or something like that. So to not cough up the $200 is insane. That was, I think, like the day before or 2 days before. On October 20th, the last day permitted to file, the state filed its first motion to extend deadline and represented to this honorable court that an extension of 30 days should be enough time for the court reporter to finish and file this transcript. Yeah, seriously, FFS. It's ridiculous. The clear and unmistakable implication of this statement is that the relevant transcript had been ordered and that the court reporter announced that she would complete and file this transcript on or before November 19th, 2025. Otherwise, this representation makes no sense. True. I will say this. Brian Steele in this case, he was aggressive in a way that he was not. I mean, he was in the criminal trial, but he was talking his shit in this civil case. You love to see it. The court did not enter an order, so technically they blew their deadline. On the 19th, the state of Georgia filed a second motion to extend deadline to file transcript. See Exhibit C. C is for Colette. This is the first motion to extend. Oh, this guy. Oh, 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 oh boy. Oh boy. No comment. Is the defendant listed as monetary? That's actually true in this case, and in a lot of civil asset forfeiture cases. The defendant is actually the property. So this is actually not that crazy. Sometimes you'll see one that's like United States of America versus like 4 golden retriever puppies, or United States of America versus like a deck of playing cards, or United States of America versus a boat. It's pretty funny. But yeah, technically the real defendants are the property. You're suing the property itself, which is insane, but whatever. So after they didn't grant so they'd already blown their deadline when this was filed, which is kind of ballsy. But they asked for another deadline after they were already past the deadline, which isn't really a thing. What emoji did I can't even tell what that is. 19th, the state filed a motion to extend the... This is, okay. This is what they're really saying. Let me fix that for you. There we go. Okay, fix that for you. Should be enough time for the court reporter to finish and file this transcript. An additional 60 days from August 18th. Okay. So basically, they're saying, basically what they're doing is like when you're supposed to meet up with friends, and it's like it's 9:35, and you're supposed to meet up at 9:30, and you're like, man, I'm stuck in traffic. I should be there any minute. If there's no traffic around on Main Street, I'll be there. Just give me 1 second. Meanwhile, like, you're still in bed. That's what they hit the court with here. But, like, you know, instead of being a few minutes late to meet up with your friends, it's millions of dollars in property. But, you know, potato, potato. Again, the clear and unmistakable implication is that the transcript of an order, and the court reporter stated that she estimated she would be able to complete and file this transcript on or before December 1925. See, this is the stuff that I like. These little subtle shady digs from Brian. This honorable court granted the state's motion to file the transcript on or before the 19th, but specifically warned that no additional extensions of time would be granted unless for good cause. Based upon the sworn statement of the office manager of the court reporting company, at no time prior to filing of either of the motions to extend did the state contact the court reporter or the court reporting company, attempt to order the transcript and or engage in any communication with the court reporter or the court reporting company to inquire about what time was needed to file the transcript. Approximately 8:45 on the date of this filing, which I think it was last night, Undersigned counsel's office conferred with the actual court reporter who took down the proceedings and confirmed that no representative of the state has ever contacted her to discuss or even request the transcript be prepared. In fact, it is the position of the court reporting company that because the state did not share in the takedown expenses, that the state of Georgia lacks the ability to order a transcript of the proceeding. That makes sense. You can't, they're just, like, they didn't even order the court reporter. That's true. I've got Leanne. Let's take a look at that. This is when I came into Cat Stream, was in the middle of the affidavit of Dorothea Parker, Judge Honorable Whitaker. I've actually used them before. In California. I've held this position since 23. I'm familiar with Magna's procedures for scheduling court reporters, billing for appearance and takedown fees, and processing transcript orders. We were retained by the Steele firm. Magna assigned court reporter Kessler Richardson to attend and take down the proceedings. Steele retained Magna for the August 18th hearing. The state of Georgia did not retain Magna for that hearing, nor did the state share in the appearance or takedown fees. Steele paid the reporter's appearance and takedown fees in full. After the August 18th hearing, counsel for Mr. Williams and representatives of Steele contacted Magna on multiple occasions to inquire whether a transcript of the hearing had been ordered. Oh, that's so funny. Each time such an inquiry was made, so he was checking on them. He was keeping his eye on them. He knows their moves, man. Each time such an inquiry made, I or Magna's customer service personnel contacted Ms. Richardson to confirm whether any party had ordered a transcript. On each of those occasions, including on or about November 14th, Ms. Richardson informed us that no one had ordered a transcript of the hearing. Based on my review of Magna's records, it is my understanding that as of the date of this affidavit, no representative of the state of Georgia has retained Magna for the August 18th, 25 hearing. Damn. Magna's obligation to prepare transcripts arise from its commitment to the arranging party and fee agreements with the parties who retain its services and pay the associated fees. Because the state of Georgia did not retain Magna or share in the appearance and takedown fees, it is my understanding, in my capacity as an office manager, that Magna is not obligated to provide the state of Georgia with a transcript of that hearing. That makes perfect sense. If you don't hire them, they don't have to do anything. That's just like how hiring works. Okay. This is so stupid. All right, I don't even know if I'm going to go through the full legal argument because I want to get to some of the other dumb things that happened in this case and explain like how egregious this bullshit is. Steele says they blew the deadline twice already. They're not even trying to meet it the third time. You should dismiss and give Jeffrey his stuff back. Basically, it's the appellant's job to prepare the record, have a complete record. Tiffany and I spent so much time on this and money. Actually, Tiffany paid for the preparation of the appellate record. Yeah, I know. Yeah, Tiffany did all the work preparing the appellate record in Mookchung's case. And I think she paid for all of it, unless I'm forgetting that if I paid for something. But I think she paid for everything. And we paid for preliminary transcripts while we were waiting for the formal transcripts, so that we could work on the brief such as to not blow the deadline, while we waited for the actual official transcripts that we could work from. Like that's how much of a pain it is to deal with these transcripts, and to see them just not even try, it's just such a slap in the face. They're just so unserious and disrespectful. Like, oh my goodness, to even know if they have, yeah, they do. A lot of the vehicles have been disposed of in one way or another. Like I think this is Duke's. I think the AMG was Duke's, so I think he has this back. I think the Lambo was returned. This was like leased or something, so I think somebody got it back. Like the leasing company got it back. And like I know a bunch of these. The guns were all no, they didn't contest the seizure of the guns. So this stuff's all taken care of. So yeah, a bunch of the stuff is already taken care of, but they do still have the cars. Can't Fonny have a nice purse? No, not till Thug gets his shit back. I didn't really mind the purse personally, no pun intended, but they did sell a lot of cars. They sold cars in December of 2022 while Moonchunk was stuck in Rice Street. It's a bad look politically for her to have that purse at the very least. Okay, so I want to show. I've talked about this before. There you are. Just pulling up, see if I have all of the Fulton stuff that I want for this case. Here we go. So as you may recall, there is some confusion with Martinez Arnold, aka Duke, in the timing of his response to this lawsuit, because he was in Rice Street and he didn't apparently timely respond. He may not have had notice. And so here, what the state is doing here, this was earlier this year, the state is saying that Martinez Arnold should not have the right to contest the seizure of his property because he was late to respond. Keeping in mind that here, they're not even trying to be on time to respond. So when it comes to them, they don't even need to try to be on time. But if they lock up Duke in Rice Street and he doesn't get a chance to, respond, that's not can't allow that. Okay. Here we go. The sheriff's entry of service was filed with the clerk of Superior Court of Fulton County on August 1st, 2022, so the effective date of service was August 1st, 2022, pursuant to 9-11-4. If an answer in a civil case is not timely filed, the case shall automatically become in default. If the case remains in default for 15 days, the plaintiff may, at any time thereafter, or I read that wrong, any time thereafter be entitled to judgment by default. Arnold was thus in default as a matter of law on 45 days after August 1st, 22nd, or September 15th, 2022. Arnold has now filed a motion to open default on April 14, 2025, or 943 days after he was in default and after the plaintiff's state has been entitled to verdict and judgment by default. So this entire thing is them saying, haha, too late, you suck, you lose. And they're seriously taking this position. It's insane. And they do this shit all the time. They try to give, they're terrible lawyers. They try to give good lawyers advice on what they're doing wrong. And it makes me so mad. It's just so annoying. I'm going to give you another example of that. Completely random. This. This is from the Moonton case. They say, we said that Moonton's guilty plea was not knowing and intelligent because literally nobody in the room knew what was going on. The state still doesn't know what was going on. But in any event, they say if Toonk didn't intelligently or knowingly enter his guilty plea, he should have filed a motion to withdraw a guilty plea on that basis. However, he chose to file a motion to vacate count 30. The sentence on count 30 is what a competent lawyer would say, stating he pleaded guilty to OCGA 131B and should have been sentenced according to that charge. That is correct. However, those aren't even, you can't do this. This is not even a thing you're allowed to do. You can't fucking file a motion to withdraw your guilty plea years later. You have 30 days. He's saying fuck Moontunk because he didn't move to withdraw his guilty plea within 30 days of entering his guilty plea. And he should have done that after he testified. That's years later. It's literally impossible. And instead of just doing research and thinking through this stuff, they just do these sassy little dumbass footnotes that are completely wrong. Well, yeah, I mean, there's that. But you can't do this. This isn't even a thing. Actually, let me pivot to Moontunk because, I've never done that before. I'm going to explain this to you. This is a subtle thing. I discussed this in the brief, but I haven't, it's kind of technical. Man, I kind of just want to read my appellate brief and explain it all and just asking how great it is. So the reason Moontunk's guilty plea, the reason they withheld sentencing until the completion of the initial trial in this case in the original plea agreement is because if you withhold sentencing, the court maintains jurisdiction. Until there's a sentence, the court can do whatever it wants. But then in the final version, when they sentenced him on count 30, they lost jurisdiction. When I say 30 days later, that's the simplification, but it's roughly 30 days. So they would have lost jurisdiction, I believe, like February 1, 2023. And the state's position is that Moontunks was wrong and that I'm dumb because he didn't file a motion to withdraw his guilty plea in fucking 2025. He hasn't been able to do that for years. It's just such a basic, not basic, but like, just research this. It's this fucking holier than thou attitude that they have. So frustrating. He didn't do the unlawful thing. Yes. I mean, it's like, why don't I just, I might as well withdraw Moontunk's guilty plea. I'll just go down to the courthouse right now. Why don't I do it? I have just as much right to withdraw his guilty plea. You guys have just as much ability to withdraw Moontunk's guilty plea right now as he does. That's, of course, an exaggeration, but you get my point. So frustrating. It's just like this sanctimonious attitude combined with this just complete incompetence. They're so condescending in these things. And it's just... Then they do shit like this where they don't even try to do their job. They just lie to the court for months. Mislead the court. Like, and they didn't even... Like, I don't even think they responded to Steele's motion today. He filed the shit last night. And they didn't even respond to it today. I'm checking that to make sure I'm not wrong. Yeah, they didn't even respond to it today. How do you not respond to that? It's so unprofessional. Makes me crazy. Wait, Kels, you changed your name back. Or did you not? I don't know. And thank you, FFS. All right. They respond at 5:02 p.m. of the last day. I think this is the last day. I'm not going to try to use a calendar right now because I'm tired and I don't want a Hank Brennan moment. Yes, like the stream and subscribe if you're not subscribed. Look at me totally remembering to do that on my own. What do I want to talk about? I want to see a FOIA report for dogs. That's not one of my favorite things I've ever done in Fulton County. Does it include pictures of the dogs? Unfortunately, it does not. I can actually probably get you pictures of the dogs. Actually, you know what? I was going to show you like a video of a specific officer just so I could show you his dog. But then I realized that if I show you like video of a specific officer and they're like, why are you showing videos of specific police officers on your YouTube channel? And I say, I just wanted to show people his dog. I don't think the court would believe me. They might suggest that I'm targeting the police officer. Clearly it would be for the dog. But, you know, people might, you know. No. Here's something I've been thinking about lately. What was that? Do you guys know that there's a gang war going on in the Georgia prisons right now? So the Georgia state prisons have been, do they watch my channel? I'm sure they do. There was one time when I was in a meeting with them, and I had never met them before. And one of the prosecutors, we were like setting a time for the next meeting, and the prosecutor's like, well, I know you're from California, so it's going to be pretty early from you. And I'm like, man, we've never met before. How do you know where I'm from? Are you a fan? Like and subscribe. I didn't say like and subscribe in the meeting, but I kind of wish I had. So this is, I don't know if it still is today, but earlier this week, the Georgia state prison system was in full lockdown. Maybe. So this is the shit that was going, I think this was Washington State Prison, this footage that you're about to see. Yeah, it's apparently the Bloods and the Bloods and the Muslims are fighting again. They had a little gang war earlier this year, and all of the prisons were locked down for like a week and a half, 23-hour lockdown, if not 24. And they're at it again. So the entire state's been locked down for like a week or so. It does. One of my guys, so I'll tell this story. In the last Blood Muslim gang war, I think it was like February or March maybe. Wasn't Doug caught in something like that? Doug's actually the leader of the, I'm not going to make that joke. Somebody might take it seriously. Went to the jail. Washington. Yeah, what I just showed was Washington. But yeah, so there was one prison. It was it Macon? It was, I can't remember which one it was. But there was one prison in the entire state that didn't like devolve into open gang warfare. And they like everybody behaved. There was no problem whatsoever at this one prison. And their reward for not engaging in brutal warfare was they got like a chicken tender from Raising Cane's. And my guy, he told me about that. And I was like, if they don't give you more than Raising Cane's next time, personally, I'd probably just riot on principle. Like, one chicken tender for not violently rioting? That's a terrible trade. Yeah. I didn't ask if there were like fries. Because those Cane's fries are actually pretty good. But yeah, that was their reward. That's true. I don't know about the bread. It's true, Kels. It's true. I know that's one of the better. I can't think of which one it is. I could look it up, but hold on. I don't want to show you the name. Let me change. Let's look back to the dog for you while I look it up. It was at Hancock Prison. Yeah, seriously. And like one of the things I've kind of realized about the Georgia prison system, I asked my guy, I say he's my friend at this point. He's like clearly innocent to the point that like I get mad and he just laughs about it. He's doing a life sentence and he's just clearly innocent. And like I get mad and he's just like his attitude is just like, bro, how did this happen? He's like laughing at it at this point. I wouldn't do that shit. This is a case where somebody else confessed to the murder, credibly confessed to the murder. Have I ever eaten at Philippe? I don't know. I don't think I have. Hold on. Let me grab the puppy. Bro, I'm telling you, Moontunk has the mental fortitude of like an actual monk. Monk-tunk. I'm serious. Every time that me and Tiffany talk to Moontunk, he ends up calming me down. I'm not even kidding about that. He's like, it's okay, James. Don't worry about it. Oh, man. Oh, man. Let me look through my cases. He's he really is. It's actually deeply frustrating. Ooh, I know what I want to look at. I know what I want to look at. Wait, I forgot what I wanted to look. Oh, right. There's some Here we go. I'm just pulling up this PDF. Familiar name. Some of you may recognize it. Longtime friend of the stream, longtime subscriber, big super chatter, Tyrone Blackburn, was recently sanctioned in another case, apparently. This would be in New Jersey. This is 4 days ago. I haven't even read this yet. I thought maybe we could take a look at this together. Judge Gordon, pending is an OSC as to why this court should not impose sanctions upon Tyrone Blackburn. I don't know why Blackburn is folklore on this channel, except you mentioned them a lot. Basically, Tyrone Blackburn is like... You know, they used to call John Gotti the Teflon Don because nothing stuck to him. Tyrone Blackburn's kind of like that. He just uses AI in every single case. In every single case that he takes. And he gets involved in these massive cases. And he fights the Spyros and Takapinas of the world. He picks fights with them. And then he uses AI in the most obvious ways possible. And somehow he just gets away with it. It's just... That's the lore. Like, he's untouchable. Why are people hiring him? Because he'll sue anybody. But if I had to pick a thing that, like, I really find offensive about him, it's his fashion sense. Like, this isn't that bad. I don't know why he's using the senior prom picture. Did he upgrade his website? Oh, this is disappointing. I feel personally betrayed. Ugh. He uses AI in court. In his briefings, he uses AI in, like, literally every single case he does. I don't know if it's literally every single one, but I'm not using that as hyperbole. Like, every case in which I'm familiar with his work, he used AI in briefing to just make up citations. And he just never gets in real trouble. Okay, Tyrone Blackburn of T.A. Blackburn Law, counsel for plaintiff Leslie Gardner, pursuant to Rule 11. The OSC stems from the court's inquiry. Does he do YouTube? I don't think so. But was he in the news for the AI? He has been in the news mostly for he does other unethical stuff too. He has an IG post going off on Takapina. I bet he does. I think he ran over a process server one time. I think he ran over Takapina's process server. Or something like that. Actually, they should put AI as the fourth A. Attorney, authority, advocate, artificial. That would be truthful. His IG is a treat. Yeah, he says some stuff. The OSC stems from the court's inquiry and later confirmation that Mr. Blackburn cited to a non-existent case, United States versus Masha, the Masha site or Masha citation, and fabricated legal propositions derived from generative artificial intelligence in support of plaintiff's opposition to defendant's motion to dismiss. Sorry, I did that for Aaron. Is that illegal or just frowned upon? There's nothing technically wrong with using AI. The problem is that AI will just make up stuff that's not correct. They'll just make up citations that don't exist. Like this case here, this Masha case, it just hallucinates the case and, talks about what the case says when there is no such case. Or AI will just take a random case name that it scrapes from Google and then just make up stuff about the case. So AI in and of itself isn't, illegal or bad. It's just AI is not good enough that there will be some mistake in it that is bad. Yeah, exactly. So at the end of the day, yeah, that's the better way to put it, Kels, is at the end of the day, it's not the AI itself. It's that there's stuff in the brief that's just clearly incorrect and just fabricated. The court provided an opportunity for all counsel to respond to the OSC and then held oral argument. Yeah, that's pretty typical FFS. In his response in an oral argument, Mr. Blackburn confirmed that he indeed used AI that provided him with hallucinated case law and propositions that he then incorporated into his response brief, and that he failed to verify on subsequent review. This shit's so stupid. For the reasons set forth below, the court will impose both monetary and non-monetary sanction. This is Rule 11. This just says the lawyer, if you sign the brief, you're responsible for what's in it. You have to read it, and it's your duty to make sure that everything you put into the brief, is a reasonable, good faith argument, that it's real. And courts have the power to sanction you if you don't live up to that, whether for AI or for other reasons. Unfortunately, the use of AI without proper oversight has become a prevalent issue for courts across the country. Numerous examples exist where district courts have found legal briefs containing AI hallucinated case law masked as actual legal authority. These examples highlight that AI can generate a legal proposition that appears to come from a judicial opinion and is even properly cited under the Blue Book. But there is just one problem. It is not real. AI made it up. When this occurs, courts have found it appropriate to impose monetary fines ranging from $1,000 to $6,000, among other sanctions, on attorneys who violated Rule 11. I think it should be a $10,000 minimum. We watched the appeal on that issue. I showed the Ninth Circuit case. The immigration case. I think it should be $10,000 minimum. Probably higher. Just going through the cases. Turning to the instant case, the court finds Mr. Blackburn's conduct plainly violated Rule 11. Mr. Blackburn admittedly failed to make a diligent inquiry into the veracity of the Marshall citation, even after defense counsel specifically highlighted the questionable nature of that citation in its reply. When that issue was directly raised at oral argument, the court held an off-the-record sidebar with all counsel in an attempt to quickly identify what problems may exist with the citation and hopefully either resolve those problems or identify that particular citation as an unreliable hallucination. What am I misreading? Mr. Blackburn contends the court did not set any timeline or deadline for him to advise the court as to the circumstances. That is also untrue. At oral argument, Mr. Blackburn was directed to provide counsel and the court a copy of the Masha and an explanation for the erroneous citation by close of business on November 18th. And when he failed to do so, this court brought on an order to show cause why he should not be sanctioned. Parties dispute what deadline the court may have set for Mr. Blackburn. Blah, blah, blah. Ultimately, any deadline is relevant. True. As is undisputed, the plaintiff not only failed to provide information about the marshal citation, but also failed to respond at all to inquiries by counsel for defendants asking for further clarification, including communications with the court on which Mr. Blackburn was copied. Given that Mr. Blackburn's only response was silence, the court issued the OSC. Only after receiving this OSC did Mr. Blackburn file a letter dated November 30 and submitted to the court early on the morning of December 1, providing any explanation on the issue of the citation. In responding, Mr. Blackburn provided some general details about recent personal hardships, probably like running over the process server, and request relief from the OSC hearing scheduled for the 3rd. Defendants were given the opportunity to respond and provide a short letter brief encouraging the court to issue sanctions. The court then denied plaintiff's request for an extension and held oral argument. Despite multiple forms of notice and warning, proper verification did not occur here. Mr. Blackburn affirmed that he re-reviewed his brief in preparation for oral argument on the motion to dismiss in light of the admonitions from the Western District of Pennsylvania. In Mr. Blackburn's letter response to the OSC, Mr. Blackburn acknowledged and informed the court that he has previously been sanctioned in another jurisdiction for inappropriate reliance on AI-generated case law in Jakes versus Youngblood. I think Kat has a whole video or multiple videos on that. Nevertheless, for whatever reason, Blackburn failed to identify or correct the hallucinated marshal site relied upon in his briefing. Thus, the court is satisfied that Mr. Blackburn violated Rule 11 due to his negligent reliance on AI. Hey, vague and ambiguous. I'm just kind of making it up as I go along here, much like Tyrone Blackburn. In finding that Mr. Blackburn violated Rule 11, the court will impose a monetary sanction, accordingly sanctioning the higher end of the range and warranted here, in light of the existence of pattern of behavior on the part of Mr. Blackburn and his failure to provide any response to defense counsel or the court when this issue was specifically brought to his attention. Let me see. Sadly, this pattern conduct does not appear to be limited to Mr. Blackburn's failure to respond in a timely manner to inquiries in the course of this litigation. Hey, Doctor. Dr. Von de Kay is smart. Or Von de Kay? Yeah, just knowing like medical terms, it was kind of throwing me off. Like apparently Haldol causes tremors, which is why it's not used in the general public, but apparently is sometimes used in prison population. I learned that today. Vonda, okay. I wasn't sure if it was like Von Decay or Vonda, space K. Vonda, got it. Okay. The court notes, after being sanctioned in the Western District of Pennsylvania, but prior to arguing the motion to dismiss, Mr. Blackburn identified and independently undertook corrective actions, i.e. CLE courses. Guys, no CLE course has ever helped a lawyer with anything. It's such a waste of time. Like, maybe you'll find one that's interesting, but they're just not helpful. Like, you learn so much more just doing the work. That's like the biggest part of the law. I don't think I've ever done a CLE course that changed my perspective on anything. Okay. Despite these preventive corrective actions, Mr. Blackburn nevertheless again failed to act. I hate CLE. My favorite thing, the very first CLE that I ever went to was when I was still in law school, and it wasn't CLE for me, but it was like an event that was also CLE. And my tax professor, he actually fell asleep behind me at the table behind me. And I just felt so happy to like see him be a student again. He looked physically pained, and then he looked asleep. Yeah, that's probably true, Trenton. Given this pattern of conduct across multiple jurisdictions, the court concludes it is inappropriate also to impose non-monetary sanctions. Specifically, this court will require Mr. Blackburn to self-report this opinion and order underlying OSC to the appropriate attorney licensing entities in New Jersey and New York. Okay, let's see the money. Mr. Blackburn is sanctioned with a fine of $6,000. $500 a month is so low. It's so ridiculous. It should be $10,000 minimum. The attorney I worked for would typically make a trip out of it. Man, they're so good. So when I do CLEs, or when I did at my firm, back when I was at the firm, they have so many things in place to make sure that you're actually watching. So like what you want to do is like have it up on a second monitor and just have it run. But like it'll do this thing where like every 45 seconds you have to like click a button in the window. It'll like make a ding sound and then you have to click like I'm watching. So you can't do anything else while the video is playing. Yeah, I think it's possible to do like an interesting CLE, but it definitely requires some effort. I'm looking through my case list to see if there's anything fun. Oh, actually, I know what I was going to do. This would be a fun idea for Friday. I'll probably get a copyright strike for this. But that's okay. I went to the IRS forum. Best was, yeah. Tax law is really interesting.
You have seen him everywhere, but tonight you are seeing him live.
What's the sound like? Is that too loud? Too not loud enough?
Please put your hands together for Josh Johnson.
That was supposed to be a baseball, but they made it a golf ball. Nerd stuff, that's okay.
Sometimes I find myself falling down whole rabbit holes online of things, stories and stuff. And there's a case, there's a trial.
I've watched this probably 800 times. Maybe 900. You watched Scrooged? Oh, Aaron, I have because I'm dedicated to ruining my financial well-being. I have an interview to do for a PD job in Los Angeles County on Monday. I gotta convince them that I know stuff about criminal law.
Stories and stuff, and there's a case, there's a trial. It just ended, and I think it may qualify for trial of the century. I know that's premature to say, but I don't know. I think it's pretty incredible.
See, the problem is, like, I do know stuff about criminal law, but I'm going to sound like I'm lying. Do you know how to defend a DUI case? And I'm like, no, I have no idea. I just do RICO and murders. Like, no, but that's not how anything works. And only in Georgia Just one state on the other side of the country.
Incredible. The trial of Young Thug just ended. Now, if you don't know who Young Thug is, he's a rapper. It's not a dog whistle this time. All right? Young Thug is a rapper that was on trial in Fulton County in Georgia, right? Basically, the state's case, what they were alleging was that he took all of the money that he made from music and he funneled it through and to a gang called YSL, a gang that he was supposedly the leader of, right? And that's the state's case. And the judge in the case looked exhausted. I've never seen a judge act like this before. Every time the court camera cut to her, her head was in her hands. And I'm not gonna act like I know the law, okay? My understanding of the law sort of begins and ends with Law and Order SVU, all right? So I know you can sustain.
You know, my favorite thing about this routine is like after the first 5 minutes, he doesn't really tell any jokes. He just says what happens. Oh my God, don't even mention that. Detective Dennis, I can't with him. Yeah, I talk about YSL a lot because it was I didn't know anything about criminal law or really have any interest in criminal law until YSL, because there was one night when I couldn't sleep and I saw a video called like "Watch This Lawyer Get Thrown in Jail," and it was Brian Steele. I didn't know it at the time. I was like, this guy looks all fancy. I bet watching him getting thrown in jail will be really funny. And so I got clickbaited into watching the video of Brian Steele getting locked up. And I was like, oh man, that's crazy. Let's spend a reasonable amount of time looking into this case. And anyway, like a month later, I quit my job and started working on the case eventually. So YSL was kind of the case that like led me to be a criminal defense practitioner. Was that your introduction to Merchant 2? Yes. And Joel, what's his face? Joel McDermott.
And you can object. I've never heard a judge be like, you can't do that. She said it a lot. And now the prosecution in the case, the prosecutor had given out a lot of plea deals.
Yeah.
Ton of plea deals. More plea deals than I thought you could give out. I didn't have a number in my head, but this felt like an egregious amount of plea deals. It just felt like she was going to the hood like, you get a plea deal, you get a plea deal, you get a plea deal, you get a plea. She was basically giving a plea deal to everybody in Georgia but Young Thug, right? And she was giving these plea deals in return for their cooperation, their testimony that she would use to piece by piece paint the bigger picture that the state was alleging that Young Thug's the leader of YSL. Everything they do is by his direction. All his money goes through and to them, right? And the only problem is the prosecutor in this case gave plea deals to some of the least helpful people in human history, all right? I've never seen people less helpful than this.
Some of those people are very helpful and very kind, nice people, and I like them very much.
It was astoundingly unhelpful. I was helping my friend move one time. And he and I had to move a pool table, just us, downstairs. And our third friend was there at the bottom of the stairs just watching. And even he was more helpful than anyone that the prosecutor gave a plea deal to in this case. At least he could be like, watch a step, something. I'm gonna tell you about some of the testimony. I'm gonna need you to be patient with me because a lot of the dudes testified in this trial are going by their rapper name and they haven't made it yet. So I don't know why it's spelled like that. I don't know how to pronounce it. Just, I'm gonna say he for short, all right? This one dude
Yeah, I really like this routine. I've seen it a bunch of times. I had tickets to see him twice. I think last year or maybe like earlier this year, late last year. Oh, the pool table joke. But both times I had work stuff pop up and I couldn't go.
On the stand, right? And prosecutor asked him a very specific question, very specific reason. She goes, did Young Thug have an issue with Rich Homie Quan bringing his friend to the party, right? Now, Rich Homie Quan is also a rapper who has sadly passed away. But his friend, to the best of my knowledge, allegedly, is a gang member, right? This whole question is to paint Young Thug as a leader of a gang. That's why he would have a problem with a different gang member coming to his party, right? So the prosecutor asked, did Young Thug have an issue with Rich Homie Quan bringing his friend to the party? And then this guy on the stand goes, Thug, did you have an issue with Rich Homie Quan? Never in the history of court have I seen someone ask a question by the prosecution and then go, I'll just go to the source. And so then the prosecutor goes, no, I'm asking you. Did Young Thug have an issue with Rich Homie Quan bringing his friend to the party, all right? And then this guy goes, I'm not Young Thug, so I don't know.
See, my favorite thing about that is like that's more reasonable. Those are both more reasonable things to say than the question. Like, how is Rudy gonna know if Thug has an issue with Rich Homie Quan's friend? That's like 4 degrees of separation removed.
Moments later. Prosecutors asking question after question after question, all alleging the same thing, all to the same end, right? And this dude, he's not being combative. He's not even being rude. He's just not being helpful. And so then the prosecutor pulls up, I don't know if she pulled up it exactly, but basically references his plea deal where she goes, I have right here you answering questions definitively that I'm asking you right now.
No comment.
And then this guy.
Okay, comment. He didn't. He never definitively. You know what? Okay, we get it. I can't help myself. I want to give you one example. Number. Where are you? Oh, thanks, Vonda. This one right here. This one, that never happened. He never admitted to it at any point. And the state knew that. 1. 2, this isn't even a fact. This is like a promise. These two I'm fine with. You guys can't see anything I'm pointing at right now. This one. I was talking about this. He never admitted to these things. That's not a thing. Like, they know that. They know that's not true. And they just put it in there anyway. That was, you know what, guys? You know what? You're right, and I'm wrong. I know. They're just making stuff up. All right, here we go.
On the stand, goes, y'all wrote that. I just signed it. Never in the history of court, at least that I know of, and it's like, the internet especially was of two minds, because it was like people could not decide if these were like some of the dumbest people who had ever lived or
It was the truth. It was completely the truth. They wrote that stuff up like half an hour before the hearing.
Masterminds. Because basically what this dude is
Antonio Sledge is smarter than anybody from the prosecution.
saying in open court, right, is, look, you were about to give me how many years? I didn't want to do how many years, and you told me if I signed the paper, I wouldn't do how many years, right? So I signed the paper, but I'm not about to perjure myself. This dude was supposed to be on the stand for 3 hours. 3 days later. The prosecution's after.
Do you know how much time of my life I've lost watching those 3 days? So many days.
Asking question after question after question, all to the same end, right? And, references again. Look, I understand that we typed it up, but what is in this is based off of what you said to the police. This is based off of testimony you gave during interrogation. And he was like, yeah, but if you gave it to me to type up, it would say something different than what you have right there, right now. Even the prosecutor was like, oh. Question after question after question after question. And finally, this dude, he doesn't snap exactly. He doesn't lose it, right? I think he just gets exhausted. And finally he says, look, I'll tell you what I told the police. I'll say anything. Like, this is a witness for the prosecution. It's absolutely insane. The whole case is insane because you even look at the fact that the case had 3 different judges. Yeah.
He doesn't get into the second judge, so I'll explain that one.
Got passed off like a bad baton. First judge was Judge, I don't know how to pronounce his name. I think it's Glanville, yeah. And this judge, he does seem to suck. Like, he does. But he also had to put up with some stuff, too, because there were jurors that were fully out of pocket during this case. Just a couple of examples. There was one juror that got picked. It already took nearly a year, by the way, to pick a jury.
There's absolutely no reason that it needed to take that long. Because Glanville called in, I think, like 2,500 prospective jurors. And the jurors that they impaneled were from like the first couple hundred. I want to show you guys something. Here we go. I think I've shown this before, but only like once. Here we go. So this is an issue that was litigated years ago. I know Doug's mentioned this once or twice. So the state actually used, they were trying to prove that one juror in the jury pool was lying about where they lived. And they actually use license plate readers. They use state license plate readers to track this juror and to surveil this juror for literally months of 2023 to try to prove that he did not live in Fulton County. Or she? He. And you are not allowed to do that. You're not allowed to use state assets to surveil jurors without court authority in an effort to prove one thing or the other. You're not allowed to do that. But they don't have time to request a transcript in 90 days. But they have time to do this stuff.
Which is insane. And then after they pick the jury, there's one juror that during the trial has started, and I think they just went to the Dominican Republic.
Yeah.
Deputies got sent to their house, were knocking on the door, everything, and then they got back, and they had to appear in court, and the judge was like, you have jury duty, you have to be here to be on the jury. And they were like, every day? That sounds wildly inconvenient. Then the judge was ready to, hold this jury in contempt and was basically giving them an out because this judge in particular loved contempt. He had a lot of contempt. The entire trial full of contempt. And gave the juror a way out. He was like, look, I could send you to jail, I could fine you, but what I'm gonna have you do instead is write me a 30-page paper on the importance of being a juror. This dude sentenced her to APA style. He sentenced her to citing sources. You couldn't see his face in the moment, but even Thug was like, damn. That's cruel and unusual. I've never heard of that before.
That's so much worse than jail.
There was another juror that admittedly, I don't even know what happened with this person, but I know that they got in trouble for live streaming the case. Which is extra crazy because it was being live streamed.
It was, by multiple sources.
Like, if you had been watching at home, you would just see them sit with the jury like...
Yes, the juror did like...
You risk jail time for an extra angle. We are...
And there are probably 3 to 5 people that were live streaming it, like Law and Crime.
Judge Glanville.
The other one, 11 Alive.
There was, there was a lot of plea deals being given out the entire case, like I said before. And some of the things that were happening was, this is me guessing, but there were people that were not being super forthcoming, that they probably didn't necessarily have to be, but they were in some sort of trouble. And so the plea deal was just given just as an extra, it's okay, you can talk, we just need to get this guy, right? And even with that, there were still people that didn't quite want to testify. And then there were people that were being so difficult, state's witnesses who were being so difficult that the state just could not get anywhere.
Oh, that's true. I
You know?
forgot about her.
And there was one person, star witness.
Kenneth Xavier Copeland.
Basically, the prosecution needed a through line. They needed something that would connect everything. And so they laid a lot of it on one person in particular. Okay? And they needed his testimony so bad that they pretty much gave him immunity on the stand. I didn't even know you could do that. It sounds made up. It sounds fake. I feel like he thought it was fake too, because he was like, immunity on, so if I say something on the stand, answering one of your questions, and it implicates Thug, but it also implicates me, I'm okay? Yeah, you're okay, you have immunity. Immunity on the stand, you're gonna be good. You sure? Yeah, you're gonna be good. Okay, I'm not even joking. He goes, okay. Okay, but what if it's federal? And I love that. I love a good haggle. I love, like, okay, I hear immunity, but can I get a federal? Can I get some federal? Federal, please. Can I get a little federal? Oh, it's beautiful. This dude gets all the stab, and you can tell he doesn't trust it. You can tell he's like, nah, they're up to something. Doesn't want to answer any questions, but we told you have immunity. All right. Basically compelling this man to testify, dangling immunity in his face. Sits on the stand. First question from a prosecutor. How old are you? And he goes,
Hold on, I wanna swap over here. I wanna show a ooh, wait, let's get the right moment here.
Young, you said nothing, I said
This is one of the wildest moments of the entire trial.
they had some more stuff going on, like
Was Threat at the gambling house when it got shot up by Kel?
Young, you said nothing I said can be used against me.
That's right.
Me and Threat shot up Rich Homie Coin Daddy Barbershop on Bankhead. I don't know what happened with Threat and Rich Homie Coin, but I'm a ride with my brother. And they was beefing. And yeah, we pulled up and did that.
Okay. And
grown. The prosecutor's like, what do you mean by grown? It's like, I'm an adult. Prosecutor is like, okay, seeing as you're an adult, how many years is that?
Damn,
And he goes, looks over at the judge. I plead the fifth. Truly incredible work. Truly phenomenal, They would be asking him lots of questions, question after question. And it was getting frustrating for the prosecution. It was getting frustrating for the judge because, look, maybe I'm doing my best to be as fair as possible. But when you watch a case like this,
yeah, he really is.
It does just seem like if you're a defendant, you're up against two parties. You're up against the prosecution and you're up against the judge, because everything in this case kept giving the prosecution chances, even when they would mess up. Because once again, they're not being given a lot with testimony, but there are things that they have in hard evidence. They're just not bringing them all together to make it cohesive, right? And then this star witness's testimony is not helping. So then, can't stress this enough, you cannot do this. Judge Glanville supposedly has a secret meeting with the witness and the prosecution, but not Young Thug's lawyers, right? It's something in Latin that I don't know how to pronounce, but you're not supposed to do it. I mean, and basically, in this meeting, this witness is then threatened with the dangled immunity and everything. Oh, we'll charge you for this. We'll hold you in contempt for 2 years. We'll put you in jail. All this stuff, unless you start testifying, unless you start answering questions to the best of your ability. I don't want to hear any more of this pleading of the fifth, all that stuff, right? And so then they go back to court, and he's answering questions so well that the defense gets suspicious. Defense is like, what happened between now and lunch? All of a sudden, he remembers everything. He remembered what color everybody was wearing. And then it comes to the defense lawyer's attention that there was this secret meeting. And so he addresses it in court, in front of the judge, to the judge. He goes, Your Honor, I've heard some distressing news that there was a secret meeting with you, the prosecution, and the witness. My client and I were not privy to. I don't know what was discussed. You know, this person's acting different, not like, what is this? And the judge, instead of denying it, instead of being like, that's a horrible accusation, that's not true at all, the judge goes, who told you that? And you can look at it because it was live streamed. You can look, who told you that? And he's like, Your Honor, don't worry about who told me that. That's the least of my concern. It's who told me that. The meeting is my concern. He's like, no, I need to know. This is very distressing. I need to know who told you that. And he's like, Your Honor, it doesn't matter who told me that. Is that true? Like, did that happen? Who told you that? Who told you that? Who told you that? Who told you that? Over and over and over. And it's just wild that, like, in a RICO case involving supposed gang members, that the judge is like, who snitched? No, for real, who snitched, huh? Like, hey, I need you to come up out them names. Who snitched? Ain't nobody play with, look, I will bust everybody in here right now. Who snitched? And Doug's lawyer is like, no, look, I'm not gonna tell you, all right? I'm not gonna tell you how I came upon this knowledge. I'm just asking you if this happened. I'm asking you, maybe even for a mistrial. Like, how could this happen? He goes, who told you? Who told you? I'm gonna give you 5 minutes to tell me who told you. And Doug's lawyer is like, I don't need 5 minutes. I'm not gonna tell you. That should be the least of your concern. Like, is this true? And he's like, I'm gonna hold you in contempt if you don't tell me. I will put you in jail if you don't tell me. You will go to jail if you do not tell me. It's like, look, I'm not going to tell you. You can put me in jail, but the problem is the meeting. The problem isn't who told me, right? And so then the judge does it. He holds Doug's lawyer in contempt, which is pretty terrifying. You know? This judge is basically going over and over again. Who snitched? Who snitched? I can't stand a snitch. And you know... And you couldn't see Thug's face in the moment, but he had to have been like, I know, right? And so then Glanville does it. He holds Thug's lawyer in contempt, and the bar association hears about it, and they show up to back Thug's lawyer up, because that's terrifying. That's terrifying if a judge does something, doesn't even bother denying it, and then holds you in contempt for asking. That's a scary court system. You know what I mean? Because that's one of those things. If it can happen to anybody, it can happen to anybody. Like, I know that it's a case involving hip hop, involving like gang culture, whatever. But that particular thing, that could happen to anybody. I promise you. That's very scary. And so the bar association shows up to back this dude up, and it looks like his case is going to be heard, and probably.
The least important detail, it was Gactyl, not the bar. It was the Georgia Association of Criminal Defense Lawyers, not the Bar Association. Same difference.
The contempt is going to be thrown out, but basically, they tell Glanville, it's like, there's no way you're impartial. If you're trying this hard, there's no way you're willing to just let the facts play out. And so Glanville has to recuse himself from the case. And one of the things about recusing yourself, it doesn't undo damage. The case just goes on, So there's still this like contempt hanging over Thug's lawyer's head and stuff. And then they move on to the next judge, and the next judge was the judge for a day.
I would appreciate this point. It means a lot.
I'm not a judge, and I don't know how judges get cases and stuff. Apparently this case was just given to her randomly and everything, and then she got the case and she was immediately like, hey, y'all, I can't. And so many people were like, why? What's the problem? Don't worry about me. I can't right now. And so then the case goes to the third judge.
Okay, so I think this might be the actual craziest part of the YSL case. And nobody really, at the time it got some notice, but this might be the craziest thing that happened. It probably is the craziest thing that happened in the entire case. Relates to the reason why the second judge couldn't take the case. So let me show you this very wonderful website with a reasonable amount of ads. Okay. Look at me, baby. Here's how a deputy got caught talking to a YSL defendant on Instagram. Fulton County, Georgia. Warrants released to Channel 2 Action News on Thursday reveal new details on how prosecutors realized a defendant in the YSL trial and a Fulton County deputy were illegally communicating on Instagram. Channel 2's Michael Seiden learned that Fulton County deputy Akiba Stanley was booked into jail Friday on charges of reckless conduct, violation of oath of office, conspiracy to commit a felony, and hindering apprehension or punishment of a criminal, according to jail records. According to the warrant, deputies saw Eppinger sitting inches away from his attorney, Eric Johnson, in the courtroom, using Instagram on Johnson's computer more than half of a dozen times. Each time, the deputies reported that they reprimanded Eppinger and Johnson. Defendants are allowed to use their attorney's laptops during the jury selection process, but only to review discovery. Last month, deputies say they watched as Eppinger had a window up on the laptop looking at discovery, but a separate window taking up a small portion of the bottom right corner of the screen appeared to show him typing. They saw him minimize the second screen when deputies walked near him. The day after that incident, a captain with the Fulton County Sheriff's Office took a photo of Eppinger using Instagram and messaging someone named Corin Gates. Investigators were able to identify the Instagram account Eppinger was using under the name Big Briss, which is his nickname associated with the YSL Street Gang. It's just Chris with a B instead of a C. After looking through the other accounts it was following, they found Short Nest for Life, which only followed 3 other accounts. One of those accounts was associated with another deputy who works at the Fulton County Courthouse. When questioned about the account, the deputy said he believed Short Nest for Life was Stanley's account. Stanley's middle name is Corin and is associated with an address on Gates Ave, which would account for the use of the name Corin Gates, the warrant alleges. In May, there was a violent altercation between Eppinger and a detention officer in which Eppinger was actively resisting being detained. Investigators say Stanley stood by and did not assist in detaining Eppinger. When he became agitated after the incident, Stanley, the deputy, rubbed his back to comfort him and said, "Look at me, baby," the warrant states. Authorities say Eppinger gave Stanley a birthday card purchased from the jail's commissary signed Big B, which is short for Big Briss. The warrant goes on to say that an investigator watched Eppinger typing on Instagram, smile, and look up at Deputy Stanley. He stated that he then saw Deputy Stanley look at her Apple Watch, type on it, look up, and smile at Eppinger. This happened several times. Prosecutors used these new warrants to name Eppinger's attorney as a co-conspirator and have his case separated from the other 8 defendants. Both Instagram accounts appear to have been removed from the social media site. So Stanley, the deputy that was hooking up with Eppinger, who shot a cop in the head, among other things, the deputy was Judge, was Ingram, I think? Yeah, Judge Ingram's former, her personal bailiff, I guess. So Stanley, that deputy and Ingram, knew each other and had, a professional relationship. So that's why she had to recuse herself. So when the joke is, the judge was like, just no, it's actually 1,000 times crazier than all that. I hope that made sense. I mean, it didn't literally make sense because that's insane, but hopefully it made some sense.
You know, the judge just, that judge. The case goes to her and she does her best. But it's very difficult. It's very difficult because there are things happening in the case that should just never happen. They actually had an officer come in who was, I guess you could almost call him a specialist in RICO cases through his police work, right? And even he made a mistake on the stand that had the defense asking for a mistrial, because basically the state handled the case so poorly, so messy, just so confusing, right? That the defense would be asking for a mistrial consistently. They were asking for a mistrial the way that you act when you got 2 cards left in Uno. Anybody do anything, you're like, oh. Defense would call for a mistrial. Non-stop. That's a mistrial right there, Your Honor. He just sneezed. That's a mistrial. He gonna get everybody sick. Because this witness on the stand, his testimony, I'm pretty sure, had to be thrown out because even though he's an expert in RICO and everything, it was 2 things were revealed that were pretty distressing. One, it's a RICO case, so they're trying to get everybody on everybody's crimes, but they never bothered to really look at the financial records of Thug. Which is pretty insane if you're telling me that all the money he makes, he runs through and to a gang. And you didn't bother to check a Chase statement or anything? That's wild. And then, while his officer is giving testimony, he makes a mistake that obviously wouldn't be called out by the prosecution, but does not get called immediately. And then the defense hears it, and then they're like, this is crazy. We can't allow it. Basically, he references past convictions as part of a testimony to what this person would have done in this case. And you can't do that. You got to judge it by the merits of the evidence you have in front of you about what happened right now, right? And at one point, the judge loses it. She storms out. The judge goes, I can't take it anymore. She hadn't even been the judge the whole time, but she was like, this is insanity. And you couldn't see his face, but you could imagine Thug being like, I know, right? Like, and so she almost grants a mistrial. You know, there's a mistrial with prejudice and mistrial without prejudice. Mistrial with prejudice is basically don't even bring it up again. Mistrial without prejudice is like, okay, you didn't make the best case, or something happened, or a bunch of jurors went to the Dominican Republic, so like, we can try it again later.
And so, you know, the judge at one point has had it with the prosecution and is giving like a full-on, you just so rarely hear people talk to like this on a live stream that aren't on a Zoom call at home. Like this, she was just like, she was looking at the prosecution and she was at her wit's end, and she was like, I don't know what to say to you. Like, I don't know, with the years of experience that you have, I don't know if you were willfully trying this case as badly as possible, or if you were just so unorganized that you can't seem to string a coherent thought together on how two things are related. And we've heard testimony. There are people that don't show up. We're leaving at 4:25. Like, what is happening? And the whole time, prosecution is like, you know, you ever just take your talking to because you know you're like, yeah, it's pretty bad. Yeah, and you're like the prosecutor had the same nod that dudes have on the street when they getting yelled at on Valentine's Day. It's just like, just go ahead and nod. Accept that you've messed up. It was so bad. You know, and it'd be thing after thing after thing, whether it was jurors, whether it was judges, you know, whether it was just wild testimony. There were people so uncooperative, right? Like, there was one point where they showed this guy a picture, right? And it's a picture of him and Thug and two other people, apparently with the person, I don't know, I didn't see the picture, but apparently with the person who was murdered, right? Because that's one of the charges. There's drug trafficking, there's like gun running, there's all this stuff, but there's also a murder, right? And when it comes to the murder, that's one of the big ones, because they're alleging that Thug paid for the getaway car, right? And so once again, not checking his financial record seems like an oversight. I'm not a lawyer. I'm just saying. And they show a picture, right, with all these people to someone on the stand. And they're like, do you recognize anyone in this picture? And he's like, I see me. Okay, fair enough. Even when it came to the star witness, there was one time where they simply asked this dude, when did you meet Young Thug? And he was like, before I went to jail. And just for the sake of clarity, the prosecutor tried to clarify, which time before you went to jail? And he just goes, you're right.
That was a funny moment. That was a moment of levity.
And I don't know how you handle this sort of thing, because this ended up being the longest trial in Georgia's history. Also one of the most expensive, if not the most expensive, because I guess plea deals cost a lot of money. And it gets so bad that every day defense is like, hey, mistrial's still an option. You want to hit it with no mistrial? You can hit mistrial. But then, the prosecution would do something that would kind of warrant a little bit of a mistrial. Like there was even one point where they had someone on the stand read a caption from an Instagram post. And this caption had been poured over because basically through the hashtags, what a lot was being alleged. Because, whenever there's letters, whenever there's numbers, it could have no meaning or it could have double meaning, or it could mean exactly what the prosecution wants it to mean. It could mean what the defense wants it to mean. And so they were arguing about this one picture over and over again before they would let the person just read it out loud to the jury, right?
This might be the dumbest thing that happened. It might be. It's up there.
Because then, I don't know if it's a gang, and I don't know if that was what the prosecution was alleging, but there was one point where the prosecutor was asking someone on the stand about a series of numbers, right? And a lot of people will sort of rep their area code. That's just a common thing throughout America, right? Exactly. That one, that's one of those things. It's like it's so unifying. Everyone does it. Like sometimes you just can't help it. Yeah. But this is my thing. The dude on the stand, prosecutor asked him, "What's 374?" And he was like, "Numbers." Maybe it's a gang, maybe it's not. I have no idea, right? But basically, there's this one picture that's being poured over and over again, and this was the straw that sort of broke everything, right? Because they made agreements and they had even redacted the picture so that only what would be read was what the prosecution and defense agreed on based off of the evidence that they were both showing, right? But then when they actually gave the picture to the person on the stand, nothing was redacted. And the prosecutor had them read everything. And so then the defense is like, "Your Honor."
I still think that was intentional. I think that was 100% intentional. I think they meant to do that.
I've never heard a lawyer have to go, "Your Honor," kind of like, "Mom," like. But this was it. "Your Honor, we just went over the thing. Why would Shaw?" And sure enough, judge agreed. Judge was like, "Look, I gotta do something else with my life too. Like, it's just, it can't just be this." And the judge said an interesting thing, and like I said, I know a little bit about the law, most of it, what not to do from this case. But the judge says something where she's like, I'm basically trying to salvage something here because I don't want an entire jury's 11 months to be wasted. I don't want, which to me is a little weird. Their time's already been wasted. Like, this is about seeing if someone did or didn't do something, And so that statement was said, but then, judge turns to the defense and goes, I'm not gonna grant you a mistrial with prejudice, but would you like a mistrial without prejudice? And defense was like, yup. And then she was like, I'm inclined to give it to you because this whole thing, this right here, no. No. And so then, they get to plea dealing a bunch of people day after day after day. And then they actually go to Thug and they're like, look, you're facing like 25, 40 years for all the things that we are alleging, right? But we'll give you probation, right? We'll give you probation if you just admit that you are the leader of YSL, a gang where you take all the money and you funnel it through into the gang, and everything they do is at your direction. Like if you'll just say that, probation, you'll be good to go, right? And then Thug says, no, I'm not just gonna accept. You came to me to make your case for you. You know what I mean? No. And that's a very, I don't know, to me, that's a very, like, brave thing. Like, I don't even fully understand all of the conditions around the sentence that he actually got, but that was what he was initially presented with. And he said no. And then the state said, okay, we're going to make sure that you do 25 years. And that doesn't sit right with me. And it obviously didn't sit right with his defense attorney. His defense attorney brought it up when the judge was about to make a decision. Basically, he says, Your Honor, the state came to us and they said he could do probation if he signs this piece of paper, or he could do 25 years if he doesn't. And I'm just kind of curious why the state would allow someone that they're so sure is a racketeering, drug peddling murderer to go free with probation if they're sure, right? And that he'll do 25 years if he doesn't say what they're so sure of. And the judge was like, good point. That is very hard to argue against. You know? And then the judge granted Thug probation and, went home. And there are some people that are like, man, if he could have just stuck it out a little bit longer, seen the trial to its end, there's no way he would have been convicted. The defense was ruining the state, like just at every turn. And it was mostly the state tripping over themselves, right? And I get it though. That dude sat in jail without bond. Dude was in jail for 2 years. He was in jail for a year while they picked a jury. He was in jail the entire trial, And every once in a while, don't get me wrong, every once in a while, Thug would also laugh. Because, he was facing a lot of time, but every once in a while, he'd also be like, how did we get here? This seems... Far be it for me to say, I'm just a rapper, but as far as the law goes... But what, I don't know. I don't know. I get it. I get somebody tells you, hey, you just do 3 more months, you'll go free forever. Maybe. That's scary, And it's also scary that that the state needed it this bad. That a lot of cases come down to reputation over justice. You couldn't just take the L. Right? It's like, no, you will die in prison for me to not look bad. That's terrifying, And I know it feels like it can't happen. Yeah, I mean, I don't rap, but I could see myself in a bad situation. Because it kind of begs the question, did this person get away with a bunch of stuff? Or did the state just jam someone up for 2 years? Thanks. But that's my thing. It's like I don't even know. And I'm obviously not Thug. I hope that everybody can move on in the most prosperous way possible. I really do. Everybody that testified, everybody. I wish the best for everyone, I really do. I just can't seem to think there's a level of peace you have to attain that I don't know if I have. Cause like if someone accused me of being this like drug running, murderer, this horrible person, like this that did all these things, and they were willing to put me in jail forever with a bad case that they didn't have enough evidence for. And then they were just like, you can go if you just sign it. I think it would make me mad enough to kill someone. But that's just me.
Oh, man. I think anyone accused of Polk County should just go free at this point. I agree. Yeah. You know what's funny is if we win our appeal and we withdraw the guilty plea, the case would actually be back open, which is really funny. So the Westlaw case could actually be back open again. And I'm not going to advocate for that just because it's funny, but it would be. Oh, all right. I think I'm going to call it a night. If you guys like this thing, though, I mean, we can do more like watch stuff. I don't really do a lot of stuff where I like just watch and react, but I don't mind doing it, especially on like Fridays or Saturdays or something. FN to dealer? I don't know anything about that. How TJ edition. I'm tired. I'm gonna call it a night. There's a lot of streaming today, but that was fun. I wanted to whine about a bunch of stuff, so thanks for listening to me whine. FN to dealer, signed to YSL. I feel like I've heard the name. I like this. I like the reading today, and it was back for another 2. Yeah, I had fun today. My voice was shot after that. That was a tough. I can't do that again. It's not that late here. It's only 9 here. But yeah. I'll find something new to stream about soon. Although I have a job interview on Monday, so maybe not in the next couple of days. Cool. Oh, that's crazy. Do you have the case number around? I guess I could just look it up myself. Let me get my spreadsheet. Okay. I'll give Aaron a second to get the spreadsheet, and I'll end the stream after that. Good night, everybody. I have calls to make to LA. 23 SC 189768. Got it. All right. Okay, but I'm gonna call it a night. Night, everybody. Thanks for watching, and I'll see you all soon. Later.